Welcome friends. This is the second part of question and answer series on chapter 2 of Company Act 2013. Incorporation of company and matter incidental thereto. Let's begin. Our first question is note on incorporation of a company. Incorporation is the legal process by which a company is formed and recognized as a separate legal entity. Under the Companies Act 2013, this process is crucial for ensuring that the company is properly registered and adheres to legal requirements. Steps and requirements for incorporation. Documents required for filling with the registrar. Memorandum of Association. This document outlines the company's name, registered office, objects, liability, capital, and in the case of the one-person company, the name of the nominee. Next one is the Article of Association. This document contains the internal regulations for the management of the company. It governs the relationship between the company and its members and among members themselves. Declaration of Compliance. A declaration must be provided by an advocate, chartered accountant, cost accountant, or company secretary confirming that all legal requirements have been met. This declaration must be supported by the person named in the article as a director, manager, or secretary. Affidavit from subscribers and first directors. Subscribers to the MOA and first directors must provide affidavits affirming that they are not disqualified by any law from holding office and that the information provided is correct. Address for correspondence. A temporary address must be provided until the register office is established. Particulars of subscribers. Details including the name, residential address, nationality, and proof of identity for each subscriber. Particulars of first directors. Information about the first directors including their names, director identification number, residential address, nationality, and proof of identity. Consent of directors. A written consent from the director to act in their capacity. Registration and certificate of incorporation. Upon submission of the above documents, the Registrar of Companies will review and register them. The registrar will issue a certificate of incorporation once the documents are verified and accepted. This certificate confirms the legal existence of the company and includes a unique corporate identity number. Maintenance of documents. The company is required to keep copies of all documents filed at its registered office for the duration of its existence. This ensures the transparency and provides a record for future reference. Penalties and consequences for false information. Providing false information or suppressing material fact during the incorporation can lead to severe penalties under Section 447 of the Companies Act 2013. This section addresses fraud and allows for criminal prosecution. If the company is found to have been incorporated through fraudulent means, the tribunal has several remedies available, including regulating the company's management, removing the company's name from the register, ordering the company to wind up, imposing liability on the promoters and directors. Case laws. National Insurance Company Limited versus BR Enterprises 1998. Facts of the case. In this case, the company had been registered based on a fraudulent financial representation. The plaintiffs, National Insurance Company Limited, discovered discrepancies in the company's stated financial position and sought legal redress. Judgment. The Supreme Court emphasized that the integrity of the corporate registration process is fundamental to the legal system. The court ruled that fraudulent misrepresentation during the incorporation undermines public confidence and the legal framework. Consequently, the court supported the actions to deregister the company and hold the fraudulent promoters accountable, underscoring the necessity of the accurate and honest disclosure during the incorporation process. Our next question is on note on formulation of companies with charitable object, Section 8 companies. Formulation of companies with charitable objects. Under Section 8 of the Companies Act 2013, certain companies can be registered with the charitable object without the need to include limited or private limited in their names. This section pertains to entities formed with the primary intention of promoting charitable causes such as commerce, art, science, sports, education, social welfare, and more. Three provisions. Eligibility criteria. First one is object. The company must have charitable or not for profit objects, including promoting commerce, art, science, education, social welfare, and other similar goals. Next one is the application of profit. Any profits or income must be applied toward the promotion of its object and not distributed as dividend to members. Next one is the dividend prohibition. The company must prohibit the payment of the dividend to its members. Central government license. To register a company under Section 8, the central government must be satisfied that the company meets the criteria outlined. It will issue a license allowing the company to omit limited or private limited from its name. Privileges and obligations. Such a company enjoys the same privileges as other limited companies, but it is subject to specific obligations related to its charitable objects. Alteration and conversion. Alteration of MOA and AOA. A company registered under Section 8 cannot alter its memorandum or articles without prior approval from the central government. Conversion. The company can convert into another type of company only after complying with prescribed conditions. Revocation of license. Conditions for revocation. The central government can revoke the license if the company fails to adhere to its charitable objects, violate conditions, or engages in fraudulent activities. Upon revocation, the company may be required to add limited or private limited to its name and may face further actions such as winding up or amalgamation. Winding up and amalgamation. If deemed in public interest, the central government may order to companies winding up or amalgamation with the other similar company. Handling of assets, distribution of assets. On winding up or dissolution, any remaining asset after settling debt may be transferred to another Section 8 company with similar objects or sold with proceeds credited to the rehabilitation and insolvency fund. Penalties. Defaults and penalties. Non-compliance with the requirements of the Section 8 can result in substantial fines and imprisonment for directors and officers. If fraudulent activities are proven, harsher penalties under Section 447 may apply. Case laws for the same. MC Mehta versus Union of India. Fact of the case. In this case, the Supreme Court addressed the role of non-profit organizations and their compliance with legal standards. MC Mehta, a public interest lawyer, challenged the practices of various non-profit entities regarding their adherence to charitable objectives and proper utilization of funds. Judgment of the case. The Supreme Court emphasized the importance of the maintaining the integrity of charitable organizations. It upheld the principle that non-profit companies must operate strictly in accordance with their stated charitable objectives. The court also highlighted that any deviation from these objectives or misuse of funds could lead to revocation of licenses and other legal consequences. The next question is on a note on a register office of a company. The concept of a registered office is fundamental to corporate structure and operation under the Companies Act 2013. It serves as the official address of a company where all communications and notices can be sent and received. Here's a detailed overview of the provisions related to the registered office. Key provisions: requirement to have a registered office. Obligation: a company must establish a registered office within 15 days of its incorporation. This office should be capable of receiving and acknowledging all communications and notices. Verification: the company is required to verify its registered office within 30 days of incorporation. The verification process is conducted in a manner prescribed by the rules. Display and communication. Display of information. The company must display its name and address of the registered office prominently at every business location. The name and address should be in a legible letter and, if not in the local language, also in the local language script. Business communication. The company's name, address of the registered office, corporate identity number, and other contact details such as a phone number, fax number, email, and website, if any, must be printed on all business letters, billheads, letter papers, notices, and other official publications. Other documents: the company must also print its name on financial instruments like hundies, promissory note, and bills of exchange. Change of registered office. Notification of change. If a company changes its registered office, it must notify the registrar within 15 days of the change. The notice must be verified in the prescribed manner. Limits on change. Existing companies. For companies existing before the commencement of the Act, changing the registered office outside the local limits of a city, town, or village where it was initially situated required a special resolution. New companies. For newly formed companies, any change of registered office outside the local limit must also be approved by a special resolution. Jurisdiction transfer. Changing the registered office from one registrar's jurisdiction to another within the same state requires confirmation from the regional director. This confirmation must be communicated within 30 days of receipt, and the company must file it with the registrar within 60 days. Certificate of change effectiveness. The certificate issued by the registrar following the confirmation of the change is conclusive evidence that all statutory requirements have been met. The change takes effect from the date of the certificate. Case law. State of Maharashtra versus the National Company Law Tribunal, Mumbai, and others. 2019. Fact of this case. This case involved a dispute regarding the change of a registered office of a company from one jurisdiction to another. The company had moved its registered office and did not follow the correct procedures for notifying the registrar and obtaining the necessary confirmations. Judgment. The National Company Law Tribunal (NCLT) emphasized the importance of the complying with the procedural requirements for the changing the registered office. The tribunal highlighted that failing to follow the statutory procedures could lead to a legal complications and invalidation of the change. The tribunal ordered the company to rectify the procedural lapses and comply with the requirement for the registering the change. Thank you. Thanks for the watching. If you found this video helpful, like and subscribe for more legal insights. Got any questions? Drop them in the comments. Share this video with anyone who might find it useful. See you next time. Thank you.